Article 26, rather Article 23, sub-article 26, paragraph C. My Lord, I will make reference to a number of authorities that have brought out Article 23, 23.6. Being the spirit, my Lord, being protection and safeguard the sanctity of the right to liberty, as well as guarding against abuse of the court process. My Lord, I will refer you to the decision of Besigye Stephen, miscellaneous application number 021 of 2025. It's a very recent one. My Lord, th July to be exact, by Justice Flavia from 30th July 2025. And my Lord, on page 4 of that decision, your sister had this to say: bail under Article 23(6)(c) of the Constitution was introduced as a safeguard to prevent the state from keeping accused persons in prison indefinitely without trial, particularly where the committal process has been delayed. The court is therefore required to strike a balance between the applicant's right to liberty and presumption of innocence and the public interest in ensuring that those charged in criminal offences are brought to justice. And she concluded by saying, in doing so, the court should impose conditions that are fair, reasonable, allowing the accused to enjoy the benefit of mandatory bail, while also making it possible to ensure that the accused continues to attend court as required and to be traced. So the point here, my Lord, is that the right to bail under Article 23 was meant to guarantee enjoyment of the right to liberty and also safeguard the processes of this honorable court. The same decision is reflected, my lord, or rather reinforced in the authority of Kato Henry. We have our bundle of authorities, my lord. Kato Henry is criminal miscellaneous application number 096 of 2025. My lord, in this decision, my lord, they are unique means, but for the benefit of the state, I can offer them a copy. But they are there on the unique. My lord, this is a reinforcement of the earlier decision cited by my friend here, Mpanga, the one of Justice Muat. Now, this one, my lord, is about, again, Article 23, where His Lordship said, after reviewing the affidavit evidence and the applicant's submission, this court finds that the applicant was detained on remand for over 6 months without committal to the High Court for trial, exceeding the mandatory procedural timeline. The subsequent committal occurring only after this period lapsed must be weighed in the applicant's favor, particularly in the context of any relief sought as bail to prevent further prejudice. The emphasis, my lord, here is that notwithstanding the fact that one has been committed to the High Court subsequent to the expiry of the mandatory period of 180 days, is not a preclusion or a bar to being admitted to bail. My lord, the case of Besigye Enoch, which is also on record there, Besigye Enoch, my lord, on page 4 of that decision, it is criminal miscellaneous application number 133 of 2025. Which my learned friend Mpanga made reference to, but mine specifically is about the spirit of Article 23. On page 4, Justice Muata had this to say. He was quoting with approval the ratio disdendi in Sabuharia Matia versus Uganda, which is cited there on page 4. He said, the court emphasized that the High Court must protect its ability to function as a forum of justice and not an agent of oppression, particularly in cases where a prolonged detention. The court emphasized that the High Court must protect its liberty my lord, if I may read again, the court emphasized that the High Court must protect its ability to function as a forum of justice and not as an agent of oppression, particularly in cases where prolonged detention without trial continues or constitutes an abuse of court process. My lord, in this particular case, the accused persons have been on remand as of today, have been on remand for 263 days. As of today, they have been at Luzira maximum prison, which is a remand prison. Luzira maximum prison, which is a remand prison, for 263 days. My Lord, I will refer you again to the decision of Colonel Dr. Kizza Besigye. This is Colonel Besigye versus Uganda. It's bail application number 228 of 2005. (228 and 229, my Lord, of 2005. There were two bail applications. They are there in our bundle, my Lord. On page 6, Justice Ogola, the principal judge then, emphasized the role of court in protecting the right to liberty. And indeed, he explained the sanctity of this right in the following terms. I have taken into consideration the fundamental importance of bail as the judicial instrument for ensuring the liberty of the individual. In this regard, the quest for bail is a quest for liberty. The right to the liberty of the individual is next only to the individual's right to life itself. You need to underline that. The right to liberty of the individual is next only to the individual's right to life. After the right to life, the next one is right to liberty. In that hierarchy. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is so precious a commodity that during the American struggle for independence, some 300 years ago, one of the American independence protagonists, I believe it was Thomas Paine, summed up the situation with the following eloquent and immortal declaration. A declaration not of suicide and despair, but of defiance and triumph. That is quite instructive, my Lord. A declaration of not suicide and despair, but of defiance and triumph. Give me liberty or give me death. That sums it up all. These are not my words, justice of God. Liberty is the very essence of freedom and democracy. In our constitutional matrix here in Uganda, liberty looms large. The liberty of one is the liberty of all. The liberty of anyone must never be curtailed lightly, wantonly, or even worse, arbitrarily. Article 23, Clause 6, this is the provision we are emphasizing. Article 23, Clause 6 of the Constitution grants a person who is deprived of his or her liberty the right to apply the competent court of law for the grant of bail. I want to sum up what Justice Ogola said by reading the following line. The courts from which such a person seeks refuge and solace should be extremely wary of sending such a person away empty-handed, except, of course, for good cause. Ours are courts of justice. Ours is the duty and privilege to jealously and courageously guard and defend the rights of all, in spite of all. Guard jealously the right of all, in spite of all. My Lord, these are very, very instructive words from Justice Ogola, Principal Judge Emeritus. They sum up the significance and sanctity of the right to liberty, which is next to life. My Lord, it is the reason the framers of our Constitution made that right mandatory when one has spent 180 days on remand. That's the reason they made it mandatory. And my Lord, I want to emphasize the submission of my learned friend here, Mpanga. Initially, the constitutional order had provided for 360 days. Under the 1995 Constitution, it was 360 days. As a nation, we consider that to be irrational and inimical to enjoyment of the right to liberty which is granted by God. It informed the amendment of 2005 to reduce it to 180 days. And now, the state is advancing such flimsy reasons to derogate from that sacred provision of the Constitution. This court should not be used as a forum of oppression, as cited by your early brother, Justice Moore. This is not a forum of oppression. My Lord, I will recite the last authority on that. Again, it is Dr. Kizza Besigye, constitutional reference, 2005, 2006. My Lord, on page 8 of that decision, the Constitutional Court unequivocally proclaimed on page 8 that we turn to Article 26, Clause 6, B and C. We accept the general position as stated by both the counsel that the court has no discretion to grant or not to grant bail after the accused has shown that he or she has been on remand in the custody for 60 days before trial or 180 days before committal to the High Court. As regards Article 23(6)(c), this is specific now in this particular case, where the accused person has been in custody for 180 days on an offense triable by High Court only and has not been committed to the High Court for trial, that person shall be released on bail on reasonable conditions. Like Article 23(6), the court has no discretion to refuse to grant bail to such a person. In both Article 26(6)(b) and C, the court has discretion to determine the conditions for bail. My Lord, this is binding on this honorable court. This is a constitutional court decision. I don't need to emphasize the point that it is binding. All I need to emphasize again, the right to bail, the sanctity of liberty, as it was explained in that decision on page 11, where the burden is cast on you to balance the two imperatives. There are two imperatives. and these are captured here. The needs of society to be protected from lawlessness, and the considerations which flow from people being remanded in prison custody, which adversely affects their welfare and that of their families, and not least the effect on prison remand conditions if large numbers of unconvicted people are remanded in custody. My Lord, these are some of the imperatives. And finally, on page 12, this is what the Constitutional Court said. Remanding a person in custody is a judicial act, and as such, the court should summon its judicial mind to bear on the matter before depriving the applicant of their liberty. My Lord, I think those authorities are enough, but probably I also cite one of the FHRI, the last one now, because it was also cited by my friend here, Mr. Mpanga. I will go to page 36, still on the significance of this right to liberty. The institution of bail is meant to protect and guarantee the fundamental rights of the individual to liberty, the presumption of innocence and the due process of the law on the one hand, and the societal interests on the other. The most important condition is that the accused will return up for his trial and will not interfere in any way with evidence. My Lord, it's about, again, putting emphasis on the right to liberty. So I think there is no doubt that this right is one of those most sacrosanct rights guaranteed under the Constitution. Now, my Lord, with the authorities I have cited of the Superior Court, which are binding on this Honorable Court, but also those which we have cited, like the one of Justice Moata and Justice Lamun, granting mandatory bail even after committal, are equally binding on this Honorable Court, my Lord. We would like to cite the the case of Semogere and others versus the Attorney General, Constitutional Appeal number 1 of 2002, on the question of doctrinal precedent, where the Supreme Court, my Lord, stated that as regards, of course, they made reference to decisions of Superior Court being binding on lower courts. I don't need to waste your time on that, my Lord. But when talking about decisions of your brother and sister justices of the High Court, judges of the High Court, they said as regards its own decisions, the decisions of this court, it would normally be bound by them, except under the following circumstances. One, that the court is entitled and bound to decide which of the two conflicting decisions of its own it will follow. If there are two conflicting decisions, there you have discretion, the discretion to choose which one to follow. You may not necessarily be bound. But in this particular case, my Lord, the decisions are consistent. That even after remand, rather committal, mandatory bail still stands. So that first proviso is not applicable. The second proviso is that if court is satisfied that the decision was given by incuria, it's our submission, my Lord, that going by the doctrine of stare decisis, the decisions we have cited are not by incuria, because they formed the gist of the proclamations made by court in those particular decisions. I want to sum up this point of civil liberties, my Lord, by again speaking to the spirit of the practice guidelines. My Lord, the practice guidelines on bail the Constitutional Bail Guidelines for Courts of Judicature, Practice Directions 2022. My Lord, particularly Regulation 10, which talks about mandatory bail for offences triable only by the High Court. Clause 2, or rather paragraph 2 of this Regulation 10, in the case of a person who has been on remand for 180 days in accordance with Article 23, Clause 6C of the Constitution, the Magistrates' Court shall immediately refer the file to the High Court. My Lord, I want to draw parallels with a sick person who requires an ambulance. If the file of Dr. Besigye and Obed Lutale before the magistrate in Nakawa who handled the pre-trial processes was a human being, if that file was a human being, on the 19th day of May, they would have put that person in an ambulance to the referral hospital. To the referral, because the regulation provides shall immediately, upon expiry of that 180 days, immediately forward the file. And in the same spirit, my Lord, Regulation 8, time for disposal of the bail application in the High Court. The court shall consider and dispose of an application for bail expeditiously, and in any case, within 30 days from receipt of the application. Said, one shall be determined expeditiously, but in any case, if court is constrained by some supervening factors, not exceeding 30 days, my Lord. All this is meant to emphasize the point that the law accords the right to liberty the sanctity it deserves. And it is the reason, my Lord, speaking to the spirit of the law, that under Section 76 of the MCA, Parliament directed the magistrate handling such a matter that once 180 days have lapsed, don't do anything else. The next course of action is consideration for mandatory bail. My Lord, for the accused person to continue being on remand up to the present, the 263 days, when all the laws we have cited, the Constitution, the Acts of Parliament, the practice guidelines, the authorities cited, all speak to the urgency of matters relating to the right to mandatory bail. In itself, my Lord, is a negation of that spirit. To see to it that they are still on remand. And as we speak, my Lord, no arrangements have been made for the trial. The state is not talking about the trial at all. And actually, for the record, my Lord, there is still a debate. Was the committee made to this division or to the ICT? That's where we are. Looking for a forum where the trial will be conducted from. To the prejudice and detriment of the applicants, and particularly the sanctity of their rights. My Lord, the last issue I wanted to speak about the argument that the charges before the Nakawa Magistrate Court are different from the charges that were preferred against the accused persons at Machindia General Court Martial. That's an absurdity, my lord. It would be a travesty of the IST order, my lord, if that argument was accepted by this honorable court. From the facts which are not disputed, as highlighted by Mr. Mpanga here, my learned friend, the state is the one that actually kidnapped, picked Dr. Besigye and Obed from Kenya on the 16th day of November. And it is the very state, Uganda, which preferred the charges against the Obed Rutale and Dr. Besigye, Uganda, in the General Court Martial. It's the same state, Uganda, that moved the then or the defunct General Court Martial to remand the accused persons in Brazil. When you look at the chain of events, my lord, after the intervention of the Supreme Court in the matter, because it's well documented, it is the same state that preferred those charges relating to the same file before the General Court Martial. On the same set of facts which are before you. Same set of facts, same allegations. Even the particulars are all the same. Even the countries they are talking about, Switzerland, Greece, Kenya, no mention of anything different from what was before the General Court Martial. So to purport to treat those as separate charges, my lord, would be stretching this matter to levels of absurdity. So invite you, my lord, to dismiss that argument with the contempt it deserves. Finally, my lord, I've addressed you on the mischief that the Constituent Assembly attempted to curb, keeping people, accused persons, on remand indefinitely. My lord, this honorable court shouldn't acquiesce in that, shouldn't be treated as an accomplice in the persecution of the applicants. We pray that you be pleased to admit them to mandatory bail. My lord, my colleagues will address you on the issue of the sureties, because yes, Mr. Mpanga has already cited the decision of your dear sister, your land sister, my lord, not dear sister. Your land sister, Justice Comfort, on the issue of the sureties, which has not been set aside or in any way overturned. My lord, we shall continue addressing you on the same, because we have no sureties.
You say you want to present them or you want to adopt the
We are adopting those other ones, but making an addition. We do so.
To praise your lordship, Kizza, also counsel for the applicants, and I will continue and reiterate the plea, the honest plea of the applicants that they be admitted to mandatory bail. I will add a few clarifications. One such clarification, Your Lordship, is to clarify the nature of arrest. That on 16th of November of 2024, what happened on 16th of November 2024, what happened in Nairobi, Kenya, to the applicants who were going for a book launch of Honorable Karua Martha was not a mere or ordinary arrest. It was an abduction. So before you, Your Lordship, are victims of abduction. That is contained in paragraph 5 of the affidavit of the first applicant in support of the mandatory bail application, paragraph 5. Your Lordship, before they were remanded and following their abduction from a foreign capital, they were subjected to incommunicado military detention. They were subjected to incommunicado military detention at the Machindi military barracks in Kampala, Uganda. That took for 4 days, 4 clear days. And you are in between 16th of November to 20th of November of the same year, 2024. Before we go very far, this has legal implications because first of all, incommunicado detention is unconstitutional and is a violation of personal liberty. That Article 23 seeks to protect. But even more poignantly, Your Lordship, according to our law and specifically the second schedule of the 2012 Prohibition and Prevention of Torture Act, Item 2, subparagraph 3, incommunicado detention is a form of mental or psychological torture. So yet again before you, Your Lordship, are 2 victims of psychological torture